Hi, folks. With Tacitus today, your pushback channel, and thank you for joining this audio live stream. Please listen to this presentation as you would a radio broadcast. In this essay, I'd like to talk about, more broadly, I guess, judicial activism. It's probably reached its zenith in the United States and indeed all across the Western world. And to highlight this, a federal judge in the United States has blocked the Trump administration's attempt to move biological men who claim to be women from the men's prison, or from women's prison rather. So the men claiming to be women who are in women's prison, and to move them from those women's prison back into men's prisons. Now, this is consistent with the other executive orders and policy platform that the Trump administration has put forward. So you'd think no big deal, but incredibly, even though there's only a small number of people who are being affected, incredibly, a federal judge has decided to deal themselves into the game, and that prisoners in prison can somehow launch legal actions that in lightning fast speed can have the executive order signed by the president overturned. Now, judicial oversight on government actions, I mean, there's nothing wrong with that. That's always desirable. And, you know, the separate separation of powers from the executives to the legislative to the judicial and so on, those are good things, that separation and dilution of power, so that not too much power doesn't reside in the hands of one group over another. And oversight is always a good thing, provided that oversight is done by independent reviewers, not activist reviewers, not people that fancy themselves as being part of the resistance against Hitler. That's not review. That's not oversight. That's just sheer activism, which I believe is what we're looking at here, and with other instances such as the end of birthright citizenship is blocked by a judge. This is blocked by a judge. That is blocked by a judge. Now, the judges that are doing the blocking part of the activists, leading the resistance, we're fighting Hitler type network. They're not judges and oversight. And we need to just accept that the judiciary has been hopelessly corrupted. The entire legal system, the judiciary, the attorneys general, the prosecutors, the district attorneys, hopelessly corrupted by the Democrats. They've put brazenly, proudly even, put rabid activists into these roles. And they truly believe they are the resistance against white fascist Nazis that are everywhere. Now, there are no white fascist Nazis for them to oppose, so they have to invent them, and they do that with even more hysterical and crazy, insane activism. But that's the sort of people we're doing. I mean, look at Fani Willis and Letitia James and Alvin Bragg. I mean, holy fuck. And the list goes on. Chaser Bedeen and so on. So there's a whole lot of activists running around. So the legal system, the judicial system, has been hopelessly compromised. The idea that you could expect independent, impartial rule of law, apply the Constitution, apply the evidence, oversight, you forget about it. I mean, there are judges around that will do that. But you've got to assume that getting on for half the judges in the judicial system in the United States are activists. They're not judges, they're just activists. The same would go the same applies even in the first Trump administration, where female judges were wearing pussy hats, the pink pussy hats, because they were part of the resistance against Trump. I mean, what? You're a fucking judge, not an activist. But they don't see that, and they're trained in law schools now and indoctrinated, and they're not getting the high IQ people that they once did in the law. I mean, when I was doing my graduation exam to university, law was one of the things that that was right up there. It was not far behind medicine and that sort of thing. So you needed to get sort of 80% plus in the overall graduation exam from senior high school to university. You had to be like a top tier student and to get into law. But that's no more. People are getting into law now on 35% out of 100, even lower than that if you're from a minority group. So you can have an IQ of 80 and still get a fucking law degree. So those sort of people are, like Fannie Willis, those sort of people are now all over the legal system in the United States and elsewhere across the Western world. I mean, you see it here in Australia as well. So again, this is part of the globalist thing to destroy social cohesion through mass migration and then destroy the legal function of the law, that is applying the law independently and partially applying the law and the Constitution and all that sort of thing, and turning the law into some ideological relativism machine that looks at social power as being the key issue in determining legal outcomes. So that's if you look at all communist regimes around the world, what's the first thing they do is they get rid of all the judges or intimidate or threaten them, but they get rid of all the judges and they put ideological activists in there, and their job is to protect the ideology. The crimes and the law and the evidence, that doesn't really matter. What matters is the ideology, and that's the situation we're at. And we just have to accept that. Yeah, that's just how it is. I don't like it. I don't think it's good. It's a tragedy. It's happened, but it's happened. And therefore, the backup to this isn't to go randomly getting rid of judges you don't like. That's not a very good precedent to have. But it's to say, how can we stop the activism without further degrading and compromising what remains of the legal system that still functions as it was meant to, it was designed to, but has been compromised. That the only thing is, I can see, this is a suggestion that really there needs to be a conflict of interest application here. If that judge was part of any activist network, has pronounced sympathies to their social media postings and all this. They're even going back to their dissertation in say graduation from university, those sorts of things, their graduation thesis or whatever, and having a look at that and any pronounced sympathies to ideological law rather than evidence-based law, then hey, you're an activist. You can't hear this case, and then having safeguards there, then the judge can apply to a higher court to say, well, I'm not really an activist. I just hate all straight white men, or something. And then go through a legal process. But the idea that activists on the ground can go straight to an activist judge and have federal government policy halted, stopped, or overturned, that's not acceptable. That's not oversight. That's activism, and we all need to realise that and come together to oppose it. Now, on the issue of, and there could be other, I could pick any issue, but just using the transgender prison inmates to illustrate the point. Now, how is it that the activists, as in legal aid lawyers, NGO activist lawyers, trans activism groups, how is it they can find out when, where, and who is being transferred from a women's prison to a men's prison, and when it will happen? How do they find that out? Is it publicly declared in some public domain, editorial, like a newspaper or something? Is it posted in the town square? Is it like a medieval town crier gets around, rings the bell, and hear ye, the transgender prisoners are being moved? How do they get to find out? So we also need to come to grips with the issue that there are numerous informers and saboteurs inside or every government instrumentality across the board, and I think just in this transgender issue that the FBI needs to investigate who spoke to who told who, which activist group was informed and advised of this, because they typically shouldn't know about it. Now, is there some law that requires the authorities to give a prisoner, 30 days notice that they're getting moved to another prison? I wouldn't think so, but let's suppose something along those lines exists. That maybe would provide a time window. How then are these people able to contact, the lawyers and and so on. That needs to be looked at. But my reckoning would be that there wasn't 30 days notice, that somehow the clerks and the operatives who were filing the documents and who were putting together are insiders, they're informers, and they immediately contacted the legal aid networks and the activist NGO lawyer networks and the trans activist stuff. They contacted them, and these activists then drew up documents and looked around for an activist judge, which was probably pre-arranged, I would think. Looked around for an activist judge in an activist region, and went straight to that judge, got an emergency hearing. Now, contrast this with the conservative or a non-activist group wanting to get an emergency hearing. They can't get a hearing. They can't get an emergency hearing. A man wrongly accused of being a biological father of a child or children, and he can prove it on a very strong prima facie basis that he's not the parent or something like that. He can't get an emergency hearing. He's got to go on a 2-year waiting list. How is it these people can always get emergency hearings? Why is it that they uniquely can get these emergency hearings? Look at some of the legal actions that were brought by the Stephen Millers and people like that during the Biden administration. They didn't seem to get emergency hearings. Firstly, nobody was informing them. They were finding out about these things typically after the fact, and then there was a scramble to get the paperwork together. The court filings, and then they would be, but they weren't getting emergency hearings. I mean, sometimes they did, but for the most part, no judge was giving, oh yeah, I'll get out of bed at midnight and sign this order for you. That wasn't happening. And if it was happening, it's happening rarely. So why is it that uniquely these people can get these activists, we're fighting Hitler, we're the resistance, yeah, hey, while they're being paid by the taxpayer, by the way, they can get these emergency hearings from activist judges that immediately give them what they want. Now, I've read some of these filings because they are in the public domain. I've read some of these filings, not on this one, but on others, and it's talk about a piss poor argument. It's just a bunch of activist talking points that you would hear on CNN or MSNBC or at some radical leftist bullshit rally or something. They're just a bunch of talking points and no evidence, no proof. It may infringe, it may cause danger, it might cause that's not fucking evidence. And yet, on the strength of these things that could have been put together by a low IQ first-year law student in a fourth-tier college, that's enough for a federal judge to go, hey, I'll sign that, or we'll stop that damn fascist Nazi president. Excuse me. And the language of the judge's order is also very consistent with radical activist talking points. It's not a judge weighing evidence or looking at the evidence or considering it's insane. But yet they're able to get this, and they're confidently able to get it. Not only are they able to have insiders informing them, but they have all the resources in place, all the lawyers, all the whole shebang, and they're able to immediately get hold of an activist judge at midnight. It doesn't matter, and get the thing signed, and that's enough to stop an executive order of the president of the United States. Now, again, you do want oversight, judicial. You do want that. That's a good thing, in a theoretical sense, but in a practical sense, as I mentioned earlier, the entire legal system has been shot through now with activists. It no longer functions as a judicial system. So we now need to layer something else on top of that, such as an activism law or and clearly defined activism. You once spoke to a white man and shook his hand or something. That means you're Hitler. That means you're an activist. No. Clearly defined activism. There has to be some pattern of behavior and so on that as an interaction with other activists, that they contacted you to get a verdict that they want, this sort of thing. And it shouldn't be hard to get a direct sort of relationship between the activists and what they're doing and so on. So you say, look, Judge, you have to stand down from this case. You can't hear it. You're an activist. you're part of the same group of activist, lunatics that the applicants are from. So you can't hear this case. And then it has to be kicked upstairs to a higher court or to a non-activist judge or an independent judge or a panel of judges. And maybe the panel of judges decides whether or not that judge is activist or not. But the idea that you can quickly get, at any time, they can go to an activist judge and get anything overturned they want, that is what has to be neutralised. Now, if they've got a good case, fine. I don't mind. If they've got a good case, then sure. But some vague notions of, well, the trans person's human rights they may be in danger. They could be. No, that's not evidence. And if that's the standard of evidence, then it needs to be applied universally. So when a white guy applies for a job at a government department, well, he might be disallowed because he's white. He might be refused because he's straight. Then that same thing needs to apply universally. If you have this activism and you then apply the social power overlay, then that results in not only compromising but completely compromising of the intent and purpose of the law. You've been a Tacitus today, your Pushback channel. Thank you for listening.